while the Bill of Rights was still under consideration in Virginia, Madison gave a major speech on the floor of the House explaining the proper construction of the 9th and 10th Amendments. The speech had to do with the proposed Bank of the United States. Probably learned this a little bit. This is ultimately going to become the second Bank of the United States. It's going to turn into a case called McCulloch, and anyhow, John Marshall's going to get involved. That's down there. In this first Bank of the United States, Alexander Hamilton is saying, yes, the federal government has power to incorporate a national bank. No, it's not in the Constitution, but Congress's power should be broadly construed to do whatever is necessary or helpful for the good of the United States. James Madison says, what are you doing? We promised the states that there was going to be nothing but limited federal powers. There's no power over incorporation. That's something states can do. It's not something the federal government was supposed to do. And you are so broadly interpreting federal power as to essentially erase the distinction between matters given into the hands of the federal government and matters reserved to the state governments. You're not just erasing the distinction, you're violating what we promised the state ratifying conventions. Right now, there's a Bill of Rights pending before the states that puts our promises in writing. And here Madison read several of the proposed amendments, remarking particularly on the 9th and 10th Amendments, the former, the 9th, as guarding against the latitude of interpretation, the latter, the 10th, as excluding every source of power not within the Constitution itself. According to Madison, incorporating a bank violated the 9th and 10th Amendments, which together reserved incorporation powers to the state governments. That's a federalism argument. It ties the 9th and the 10th Amendments together and uses them as rules of construction for limiting the extension of federal power and preserving the autonomy of state governments. That's federalism. Major speech, it's going to get reprinted. It's going to play a role for a number of decades. But maybe this was just Madison's particular view. Maybe he was just coming up with this in the heat of political battle. Maybe it doesn't really represent the meaning of the 9th and 10th Amendments. Well, one thing's for sure. A few months after he gave his speech, Virginia decided they wanted the 9th and 10th Amendments after all. They ratified and we got the Bill of Rights. Then in the coming decades, every major treatise writer, every writer who talked about it at all, talked about the 9th and 10th Amendments as working together to limit the construction of federal power and preserve the autonomy of local self-government. You get this in St. George Tucker's Treatise on the Constitution, the most important treatise for the first 30 years of the Constitution. You get it with other major writers as you move into the 1810s, 1820s with John Taylor. But he's a radical states' rights guy, so we can't really trust him, right? Okay, how about Joseph Story, right? Along with Marshall, one of the two major nationalists of the early constitutional period, according to Joseph Story, he also reads the 9th Amendment as calling for a limited interpretation of federal power in order to preserve the autonomy of the states. And in fact, if you just do it like a Westlaw search in the old case database, 9th and 10th Amendments, you'll find hundreds of cases linking the 9th and 10th Amendments as working together, working alongside each other as federalism principles. So that creates a little bit of a mystery, right? If you go back and you read Goldberg's opinion, he writes as if the 9th Amendment has been a mystery since the time of its founding. He says no one has ever talked about it before. No member of the Supreme Court has ever talked about the 9th Amendment. There's no jurisprudence of the 9th Amendment. It's a completely blank slate. So I'm going to do the best I can today and talk about it as something actually justifying striking down a state law. Well, why didn't he know about Madison's speech? Right? Why didn't he know about Joseph Story's opinion in Houston v. Moore? Why didn't he know about St. George Tucker or John Taylor? There's a good reason why he didn't know. I have to confess that I cheated a little bit. Madison didn't talk about the 9th and 10th Amendments. He talked about the 11th and 12th. Same thing for John Taylor, same thing for St. George Tucker, same thing for Joseph Story. None of them talked about the 9th Amendment. They talked about the 11th Amendment. Some of you know why. Why? He meant the 9th Amendment, but he didn't call it that. He called it the 11th. Why? Anybody know? Go ahead. Well, you're going to nod your head first. Sure, go ahead.
Weren't there two other amendments that were proposed but not ratified when, with the rest of the Bill of Rights?
Right.
One of which became the 27th Amendment later.
Yeah, ultimately. You see, the list of proposed amendments is exactly correct. It wasn't just a list of 10 amendments. Actually, it was a list of 12 proposed amendments. At the time, only the last 10 got ratified. What we call the 9th and 10th at the time were Articles 11 and Articles 12 of the proposed Bill of Rights. For many years, for decades actually, they didn't know how many were actually going to be ratified. One of them wasn't going to be ratified for 200 years. So, so they don't know whether it's going to be 1, 7, 3, whatever it's going to be. So for decades, they just called it according to its name on the list. Madison talked about the 11th and 12th. Same thing for Joseph Story. He didn't talk about the 9th, he talked about the 11th Amendment. As decades passed, once you get to the 1830s, 1840s, people begin to think, you know what, it's probably just going to be those 10. So as a matter of popular reference, they get renumbered. They're not 11 and 12 anymore. They're now numbers 9 and 10 on the Bill of Rights. But when that happened, when the change in terminology occurred, it had the effect of obscuring all these early references to the 9th and 10th Amendments. But it's not just that. We learned a little bit about this in constitutional law as well. Once you get to the time of the New Deal, the court no longer wanted to look back at early interpretations of the 9th and 10th. This is when you get a very dramatic expansion of the court's interpretation of federal power. You get cases like Darby. Where are we? There we go. Let's stay with FDR for just a second. Darby reduces the 10th Amendment to a mere truism. It doesn't control the interpretation of federal power. All the early cases that say the 9th and 10th Amendment limit federal power, they're no longer relevant to what we think is the proper construction today. So the court stops citing all those earlier cases. And then the further back you go, the more you only see these odd references to the 11th and 12th anyway. So really, by the time you get to Griswold, it did seem as if it was a blank slate, as if there was nothing there for the court to rely upon. But the history is there, right? So what would happen if the court were to actually take seriously this original understanding of the 9th and 10th Amendments as guarding this idea to local self-government? It certainly isn't how the 9th Amendment is interpreted today. It's most often associated with individual rights as against state governments and state laws. And then not only that, the whole idea of state rights is a bit controversial anyway, right? It's associated with the preservation of slavery or with the opposition to desegregation to the 1960s and 1970s. So for many years, the whole idea of states' rights or local autonomy seemed to be necessarily a pejorative. But times change, right? And politics change. When liberals are in power, conservatives are in favor of states' rights. When conservatives are in power, liberals are in favor of states' rights, right? The right of California to allow marijuana for medicinal use, the right of states to resist assisting the enforcement of the Patriot Act, the rights of states to decide for themselves whether or not to allow physician-assisted suicide. These are all state rights arguments generated by the left, right? So the whole idea of local autonomy hasn't necessarily been associated with one party or another. Every side can find opportunity to support the idea of local self-government. All I'm arguing in my work is that when it is cited, when you do hear the argument of federalism and local self-government, it's not simply a good policy idea. It's something which has actually been enshrined in the text of the Constitution itself in the 9th and 10th Amendments. Enough for the general historical overview. That's done. Now we can just have a conversation. Yeah, go ahead.
How should that influence our understanding, though, of conservatives and a lot of libertarians usually have a negative view on judicial activism? How should the 9th and 10th Amendment, as originally understood